You are now entering a dangerous liberty zone where God-given natural rights are held sacred and exercised. This is your warning. Tyranny, fascism, and censorship will not be tolerated. Ideas will be exchanged freely. Rigorous debate and open discourse is encouraged. If you are weak and your beliefs are fragile, you should leave now. Prepare yourself. We are now live on the Dangerous Liberty Podcast. All right, folks. Happy Wednesday, everybody, and welcome to another Dangerous Liberty Podcast. We have a great show for you today. And I want to say hi to everybody over there in the comments section. There's already a bunch going on over there, so just know that I see what's going on, and I'm paying attention. But we have a great show for you, a great guest. I'm really excited about this. Every now and then we get some really good guests that I know I'm going to learn something, and it's going to be educational. And I'm really excited about having Andrea on, and I'm going to have her introduce herself in just a few moments. I do want to lay out some of the normal ground rules that we have. Number one, first and foremost, please like, subscribe, share, all those things. If you'd like to support us by becoming a member, we do offer memberships. That does help support the channel. That's really appreciated. And I'm going to go ahead. I'll probably mention this again later. I do these lives so that we can interact with you. What I'm not going to put up with is just trolls in the comments. All right. I want to have open discourse with you guys. We encourage disagreement, but I'm not going to put up with any name calling. It's just, you're just disrupting your side of the argument if you disagree with me. And if you're somebody on my side of the argument and calling people names over in the comments, we're not going to put up with that either. We want some good, solid, mature discourse. That's how we solve problems in this country, not by name calling. So if you're going to do that, you can go be childish somewhere else. Yeah, I guess without further ado, I want to go ahead and bring on Andrea. Andrea, welcome to the channel. We appreciate you coming on. I'm really excited about having you. And if you will, just take a moment and introduce yourself to everybody. And yeah.
Sure. My name is Andrea Burkhart. Appreciate you having me here on the channel. I'm a practicing criminal defense attorney for almost 20 years up here in Washington State. I started doing YouTube commentary about 3-4 years ago, and I like to focus on issues that involve the justice system, constitutional rights, very strong focus, of course, on criminal justice. So that drew my attention to the case we're going to be talking about today, the Tyler Robinson case, because really a couple of reasons. I knew it was going to be very significant in terms of being a death penalty case. So a lot of jurisdictions, you don't have the death penalty anymore. We don't have it up here in Washington. It's, of course, the most serious consequence that there is. And it gives a certain tenor to the litigation that can be expected. But I also expected, just because of the bigger implications, the fact that Charlie Kirk is the victim of this crime, that it had the potential to bring a lot of new eyes to the case, to the criminal justice system. And this was going to be an opportunity maybe for folks who, aren't true crime or, in the justice system or anything like that, to kind of be learning about this and engaging with the process for the first time. So I just wanted to kind of help be a guide for a lot of that.
Yeah. And, I was telling Andrea before we went live here, I actually know some people that are prosecuting attorneys, and and we may end up having some of them on to get their perspective, but what I wanted to do was have a criminal defense attorney on. And I know there is a lot of discussion about people's perceptions of things being weird in this case. And I just wanted to have her come on and kind of, I don't know whether you'd call it steelman the defense argument or play devil's advocate, whatever you want to call it, right? But from the defense perspective, to see what she would see as far as how she would kind of dismantle this case a little bit, or the holes that she sees in it and the discrepancies. I think, look, we all do this, right? I'm not a lawyer, but I often give opinions on how the law should work and how I think the law works and how the court process works. We're all guilty of those things, right? We're given professional opinions in a profession that we don't engage in. So I also wanted to clear the air to a lot of people and give you guys an opportunity to be able to ask questions and things like that. Now, I do have some questions that I have set up on X. I put out a notification yesterday. Hey, if you want questions, send those to me. Towards the end of this, or kind of when Andrea and I are done talking, we're going to open up the floor to questions. We will prioritize super chats, but I will try to get to as many questions as possible. And yeah, if you're not following me or Andrea on X, by the way, down in the description below is all of Andrea's social medias. Make sure you go follow her. I've been following her on X for, I don't know, a couple weeks now, and I've really enjoyed her content. And I think you will too. She has kittens as well, which is always fun. Andrea, where do you say we start? You know, there's so many people that are invested in this, that seem to be very vested in this entire thing. But I know after talking to them, they clearly haven't read the charging documents. And I don't even think they know what the charges are or what the evidence, the alleged evidence in the charging documents is. So, you know, from your perspective, where should we start on all this?
Well, I think it helps to have a little bit of background, perhaps, about just the process itself, what has been done so far, and what we're still waiting for. Because I recognize, you know, Charlie Kirk was murdered 3 months ago now, and it, you know, in news cycle terms, that's an eternity. That seems like a really long time, particularly kind of in this day and age where we're used to just on-demand information and so forth. But this is still extremely early from the standpoint of court time. Court cases often move at a glacial pace, and that's even more the case when you're talking about a situation where the death penalty is on the line. They're extremely careful with it. There's a lot kind of higher standards that get applied to what happens and what needs to be done to ensure that the process is fair. So from my standpoint as the attorney looking at this case, I think the most important thing to understand is that this case has barely even gotten started. And what we know about the evidence, about the investigation, and so forth is a tiny, tiny tip of the iceberg. Because what we've received so far is just essentially the evidence that police had at the time that they made this arrest. And it's enough to show probable cause to believe that, you know, Tyler Robinson committed the crime and should be charged with the crime. But it would be a mistake to think that that's where the investigation ended, because particularly in a case like this, what happens is you have this very short time frame between the suspect being identified and the suspect being arrested. And so there is a massive amount of information that investigators will acquire once they know who their target is. And this can include things like absolutely digital footprint is a huge one, location data, activity from online, financial information, and so forth. So a lot of this information is stuff that takes some time to accumulate. You have to get search warrants for it. You have to search them, you know, serve them. You have to, you know, receive the response. You have to process it and go through it. But when you
let me interrupt you. So basically, what you're saying, kind of like the charging documents, is what they had on the initial, just enough to like charge him and get him in prison, or not,
because because we need to get this guy off the street, right? If we're worried, we think this guy shot Charlie Kirk, this guy is dangerous, there's a public health, public safety risk. People are understandably, you know, quite nervous about this guy being apprehended. So our immediate priority is to secure him. And then the secondary priority, once we have him, is going to be to follow up on these other investigative steps. But so all that we have at this point is just that initial information that was like, okay, this is enough to justify arresting him. But it is far, far from the end of the story in terms of what the investigation has done, will do, will uncover, and so forth.
Now, is it normal for them to add additional charges as this process goes along?
Certainly can. Yes, it's not unusual at all. Evidence of new crimes can come up. Evidence of accomplices can come up. It just depends on what they uncover over the course of the investigation, but that's not unusual at all.
That's interesting. Yeah. So with the charging documents, let me ask you this, you know, with some of the elements that we have in this charging documents, and I'm sure you've read them. I know you have. We talked about it just a second ago that you've gone through these. Is there anything in particular, and we might get some more specific answers on that. Is there anything in particular that kind of stands out as unusual or suspicious, or let's quite frankly put it out there, an indicator of some sort of, government conspiracy that you've seen in the charging documents or elsewhere for that matter?
Yeah, this is honestly quite routine from my perspective. This is a very ordinary type of investigation. Most people get caught because they talk or because they're turned in. That's just fairly normal. This is at least somewhat consistent with that. We know that what led him to come to law enforcement's attention in the first place is he, allegedly made self-incriminating statements to his family members. His family members contacted a family friend. They encouraged him to turn himself into the police down there in St. George. So that's all honestly pretty run of the mill. The rest of what I see when I look through the charging documents, I'm always looking at a case from the standpoint of a defense attorney, right? And it might help too to kind of understand a little what the perspective of a defense lawyer is, particularly a public defender, which
Sure.
is what I spent most of my career doing, and is what Tyler Robinson has, right? He didn't hire his lawyers. He didn't choose them. They have been appointed to represent him. And so, it's not a situation where you get to like pick your case, pick your client, and kind of have a little bit more control over, where things are going to go with it. So when you're a public defender, it's perfectly understood. You're probably going to lose a lot of your cases, because while it's not unheard of that the actually innocent person, ends up getting charged in court, the reality is that most of the time, there's something there. And so what you're often dealing with as a defense lawyer is not like, did they do it? Because they'll often admit that they did it. The issue is just, are they charged with the right crime? Have they been overcharged? Is there some kind of consequence, some kind of sentence that is unfair, that maybe, for a variety of reasons, there should be a different sentence, there should be a sentence alternative, things along those lines. And quite frankly, it's not unheard of at all to have cases where like literally all I can do with, given the evidence that I have, is just be like, well, look, here's what it's going to be like when you get to prison. I can kind of prep
So you just bring in a care package.
Yeah, I kind of prep you for that experience. So not everything about defense lawyering is like, I'm going to try to like get this guy off at all costs or anything like that. You're trying to put him in the best position that you can. But there is just a massive amount that is outside of your control in that regard. I'm a defense lawyer. I'm not a magician. I can't control what witnesses are going to get on the stand and say. I can't control what the jury is going to think about it. I can't control like what you said when you went into the police department and you should have, shut your mouth, but you didn't, because for whatever reason, people never do. You just have to roll with the evidence you have and kind of see where it leads you. So what I do when I'm looking through an initial report like this, a probable cause affidavit, I'm looking for holes, and I'm looking for hints that like there might be something else here, something that maybe will need to be followed up on. It's maybe something that would help my case, but it might also be something that like, look, if they get this, we're done. Like we're not going to have anything to be able to work with here, and we need to be talking about like what kind of plea we're going to negotiate and stuff like that. So when I look through this charging document, there's not honestly a lot of holes here to look for. The ones that I see in particular, I see there's a phone call at 11:53. There's some kind of phone activity that's described in that probable cause affidavit. It's before he goes into the low C center. I think it's right before he goes into the bridge, like a underpass bridge.
Right.
And so I want to know, what is that phone activity? I know already that investigators are going to have his entire digital footprint. They will have it from all sides. They will have his phone. They will extract his phone. They will have all of the data that's from his phone, but they will also go to the provider end. They will get all of his location data from Google. They will get all of his location data from the cell towers. They're going to have like multiple layers of being able to corroborate a lot of this information. So I'm going to want to know, number one, does this data add up? We have a specific point in time where we can look at this guy on video. He's at this location. He's doing, he's engaging in some way with his phone. Does that correspond with data that we're able to recover specific to Tyler Robinson and his activities? It's also just going to be potentially interesting from a fact standpoint. What's he doing on his phone at 11:53 right there? What's he doing on his phone? One of the big suspicions in all of this has been, and I think continues to be, and probably will continue to be, are there other people involved? Was this, if we go ahead and work with the theory that it's him based on this evidence, it doesn't necessarily mean he was a lone wolf. He was a solo actor. So potentially some information there that could be helpful from that phone activity. There's a gap in time of about 13 minutes between when he is seen going into the Low C Center at 12:02, and then the next time he's seen starting to go up the stairs at about 12:15. I'm curious about this gap in time. What's going on? And this may or may not be answerable. I don't know. It's going to depend on a lot of factors. Like, again, is there cell phone activity that might show us he's doing something during that time period? Is there other cameras available? We can see from the still photos that have been released that there are other people around. So there might be potential witnesses that are going to be interviewed that saw him, that can describe what he was doing. But that's just a little bit of an unknown period that could potentially be helpful in terms of sorting out exactly what the storyline and the timeline is here. I have some questions about the description of the gait, the change in gait. He's described as, when they first see him on the camera, as walking with this kind of impaired gait. His right leg appears to not be able to bend well at the knee. And they kind of flesh that out in the information as, indicating possibly he's got a gun, in his pants, and it's consistent with that. So I'm going to want to see like all of the video camera, all of the video footage that we have, because I want to verify this. It's going to be a big question. Okay, let's say he had the gun in his pants. When did it come out of his pants? How did we go from this process of transporting a gun without being seen from his initial location to the roof of the building? We only have the still photographs from most of the video footage, except for the one when he's up on the roof. We already know the gun's out at that point, but it raises some questions for me because the description is having difficulty bending his right knee, but you can see in the still that his right knee is bent, going up the stairs. And if he's having trouble bending his right knee with the gait, you would just think that would be noticeable, in climbing the stair, but we know that there's witnesses there also. So again, this may or may not be anything. We really don't know.
You're right. I have seen that picture where people have kind of zoomed in, and it does look like, and again, we're pixel peeping, right? But it does look like you can actually see where it looks like what the barrel has shifted more to the front of his leg as opposed to like almost on the side of his inner thigh. Mm-hmm. And I don't know if he adjusted it to where he could get up the stairs with, less awkwardness. And again, that's pure speculation. Who knows?
Yeah, I think a lot of this is, it's just unanswered questions at this point in time. We have a theory, the law enforcement has presented a theory. They seem to have some evidence to support it, but again, there's kind of a little bit of a gap in it. Is this potentially going to undermine it? I don't know. But it's just something that I'm going to be alert to, that, how the gun got from the ground to up on the roof and then to, over there in the bushes where it was ultimately found is going to be an important part of the story. So if they aren't able to fill in the gaps in this part, it's not necessarily fatal to the case. Sure. But it is just something that I, the defense lawyer, am going to be brainstorming. Well, can I generate some kind of reasonable doubt about this? Is there a way that I can call into question how solid the state's theory is if this point in time right here, within 10, 15 minutes of the shooting is unaccounted for, or just doesn't appear to be consistent with what they're telling me has happened. The last thing that I see as kind of a hole in the probable cause information that we have so far is that the only ballistics information that we've been provided relates to the gun. We know that the gun has been identified as this Mauser 98 30-06 caliber, but we would have expected to have at least some kind of information about whether there was any kind of bullet or fragments or anything like that that were recovered from Charlie or from the scene, because that's normally going to happen as part of the autopsy, part of the evidence collection. If there's anything to recover there, it's going to be recovered. And so that would already have been a known factor, as long as there's something recovered that is in the kind of form that is able to be compared. So I would normally expect in a document like this to see something like, okay, great, you've identified a Mauser 98 30-06 rifle. Is that consistent with whatever was recovered from Charlie Kirk? Because I would think that would already be known at this point in time, but we don't have that, and we don't have an explanation for why we don't have it either. There could be explanations. Most obvious one to me is their massive fragmentation. It does happen that bullets become so deformed or so fragmented that you don't have good enough quality to really be able to draw good conclusions from it. But I would just expect them to tell me that, if that's the situation, so that I would understand, why are you not telling me this gun is consistent with the murder weapon? So again, I don't know if this is a hole or not, but it's something that I, as the lawyer, I'm going to notice this, and I'm going to be like instantly looking, okay, I want to see the autopsy report. I want to see the property log. I want to see what they were able to recover. I want to see if there's any, notes about, bullets, fragments, anything like that, just to, make sure that this is all going to be consistent and add up.
No, that makes perfect sense. And folks, I just want to remind you again, I said at the beginning, I know a bunch of other people are showing up now, but we'll continue to talk for a while, and then we will open it up to comments and super chats and questions and all that other stuff. Andrea, like, if you were a defense attorney for this case, like, what would you, like, how strong do you feel like, just, and again, we only know what we know from the charging documents, like, just based on the information that we have from the charging documents, do you feel like it's a really strong case? Would you be worried about this case? Would you, like, what would be your thought process behind this whole thing?
Yeah, it's a great question. And I'm definitely going to be worried about this case, mainly because there's so much of it that is going to be verifiable. And the words of Tyler Robinson himself that have been attributed to him, are extremely damning. And so their ability to validate that, to authenticate that, to trace that to, like, actual communications on his telephone, actual, pings going through the cell towers and so forth. If that can be corroborated, that's extremely difficult to overcome. There's a lot of evidence that, like, even sometimes DNA evidence that you can work around. You can work around because, just because DNA is on something, it doesn't necessarily tell you when it got there. It doesn't necessarily tell you how it got there. But a person's own incriminating words are so difficult to get a jury to look past, because most people just look at that and think, well, if this was me, putting myself in my shoes, why would I say something like that if it wasn't true? What would my possible motivation be to put myself on the firing line if it wasn't because that was the actual situation? So that in and of itself, I'm going to be looking at that and thinking this is going to be very difficult to overcome. I need to look at how strong their case is going to be to prove that these things, these communications actually took place. And so if that can be substantiated, that's going to be very difficult.
There's been a lot of, I don't know, rumors, speculation, questioning of the entire text chain, and I want to talk to you a little bit about that. Number one of the things that's been brought up by all the barracks lawyers out there is that there is no timestamp on this, and that's like, oh, it's this has been all faked because there's no timestamp. Is that normal? Is that abnormal for an indictment?
It's totally normal for where we're at in this stage. See, the indictment is not itself the evidence. It's a description of what the evidence is. So they're just, paraphrasing or like quoting in the document itself. They're not like attaching a copy of the extraction or what was very likely the case at this point in the investigation. Again, because this is very preliminary. What police officers will often do if there's something on somebody's cell phone, they communicated, they took a picture of something, whatever, they'll literally sit there with their own phone and like screen record it just so that they can capture it for their own purposes, know that it's there. But for purposes of court, and the evidence that's ultimately presented, they're going to go get this. They're going to extract it from Tyler's phone. They're going to extract it from Mr. Twiggs's phone. They're potentially going to, try to go to the source if they can. If there's like a cloud service, we don't know what provider they use, but often, if you have an iPhone, it might be updated to your iCloud. If you use a Google phone, it might be in your Google account. So there's just all kinds of different sources that they have to be able to go through to get like the original document, the original message, and that is absolutely going to be time-stamped and cross-validated, any number of different ways. It's just they're not at that point in the investigation yet because that takes time to do. You got to send out the warrants, you got to wait for the response, you got to with Celebrite, sometimes you got to break into the phone. That can take a while. If you don't know, if you get Tyler's phone, but you don't necessarily have his cooperation, it can take a while to break into the phone to get past his passcode or whatever. So you don't expect these things to be available, right like that when you've only just learned who this guy is, within an hour, a couple hours of arresting him.
Yeah. And so when we look at the other thing that I noticed, clearly this is almost like a summary, and it was actually very specific. And I think that's lost on a lot of people when it comes to these text messages. A lot of these are talking about specifically the rifle. And it is almost like a summarize. Is it your thought that there's obviously a lot more text messages and things like that, and that the prosecutors decided to just include this because it was relevant to the case and is what the judge needed to see to, decide on the probable cause? What's your thoughts on that?
Yeah, it looks like that. I mean, there seem to be notations in the document itself with how these text messages are reported. There's ellipses at points that suggest there's something here that's omitted. We don't know what that is, but yeah, they're not necessarily going to give you the entire dump of information because all they're interested at this point is in what's relevant to what they're trying to prove, which is that Tyler Robinson committed this crime. So if there's like side conversations or things that maybe don't relate to that, they're not going to want to include that in a document like this. So that also really not unusual, not suspicious. What you present in court is supposed to be limited by relevance. Things that are relevant are generally, admissible, barring other considerations. If it's not relevant, it's not admissible in court. So there's kind of always some sorting of information and evidence that goes on. The fact that may have happened in this case is not in and of itself a suspicious thing. That's like a perfectly normal court thing.
Now, look, these text messages, I'm sure you've read them. They're weird, right? I've never sent text messages like this, but I will say, I always find it odd that, let's say this person is the killer. All right, so this person is a sociopath or whatever else, and then what we start to do is like we project our own sensibilities on somebody that's willing to climb on a roof and kill somebody, and then clearly has some weird relationships going on or whatever else. But when we see these, a lot of people said because these are so strange in the this the vocabulary is a little bit different and syntax is strange, that these were faked. And what, as a defense attorney, what would you be able to analyze and determine whether or not these were fake, and in your own way, like prove or disprove that these actually came from his phone and they were his words?
Sure. Well, of course, as the defense lawyer, the number one thing I have access to that nobody else in the world has access to is the defendant. And so I'm going to ask him, what, if anything, can or should I be doing with these text messages? Now, I have to say, in dealing with people that are accused of crimes that you're representing, it's just a piece of information, what people say. It may turn out to be good, it may turn out to be bad, but it's just a guide to kind of lead you down the road of knowing whether this is going to be a fruitful path or not. And so you certainly hope that your client trusts you to be forthcoming about that kind of thing. It's not always the case, and so that's sort of part of the process, as well as learning to what extent I can and should rely on or trust, what my client is telling me. But that's absolutely going to be a starting point in all of this. This is Tyler Robinson's case at the end of the day. He's the one that is facing the potential consequences. And so it's kind of up to him to decide, where are we going with this? What are we fighting about? Are we fighting about, are we going to be trying to negotiate? Like, what's our objective here? Are we going to be trying to win on innocence? And your job as the lawyer is to try to kind of help them as best you can understand, like, it's like the choose your own adventure. If we go this way, here's what's going to happen. Here's what it's going to look like. If we go this other direction, here's what it might look like. So you're going to be having a lot of those types of conversations about all this stuff. But certainly the messages themselves are just, it's such a huge one, because they're trying to put that in his mouth. He's the one that has firsthand knowledge of if that happened or not. So that's the absolute first thing I'm going to be doing, is I'm going to be talking to him about it. The second thing I'm going to be doing is I'm going to be looking at just the technical validation. Again, if these are legitimate text messages, then there is going to be a record of them in the phone. Either his phone or Mr. Twiggs's phone, or both of their phones. There's going to be a record of the time frame of these things happening. So I'll get an extraction from the phone. It'll tell me, here's what message was sent at this particular time. You're going to be able to get the cell phone activity itself. When it was connecting to the towers, when it was doing these things, you're going to be able to get that from the provider side. And so you're going to be able to line those up. Do these things correspond? Yeah. Okay. Here was a text message sent at this time. That's this text message. And you should be able to, trace this conversation through all of these different ways. So that's how you're going to authenticate that the conversation was real or not. If any of those things don't add up, okay, well, now I've got some concerns here. I've got some potential reasonable doubt here that I can work with, because this is a very important part of the case. But if there's something hinky with it, process wise, then that's gonna potentially be a problem. The state's gonna have to account for why is there an inconsistency? Maybe maybe we get two different extractions and they show two different conversations. We're gonna have an explanation for that and a reconciliation of the differences. So it's a lot of big, it depends, on what you get as a defense lawyer. But I want to emphasize one more time, because it's so important. Like, the thing that they have access to that nobody else does is Tyler. They have access to Tyler and his story and what he says. And they're going to be making their decisions about what is going to be a productive use of their investigative efforts. They're going to rely heavily on what he has to tell them to make those decisions.
So you feel pretty confident if, for some reason, whether it was the FBI and everything points here, this obviously these documents were filed by the Utah authorities. Mm-hmm. if these documents or these text messages were fake, they were put in this document to get him charged, you feel pretty confident, or what is your confidence level that his defense attorney would be able to identify that?
1,000,000%. There's no way that you would be able to sneak that through. Again, just with the many layers of communications of data that is created in all kinds of different locations when a text message is sent. The feasibility of being able to fake that at all levels is just mind-bogglingly low. So no, I don't have significant concerns at all about the feds like faking or planting these text messages or anything like that. I can understand, and I, maybe share a little bit, like some questions about, well, the content of them maybe seems a little weird. And, was this just a straightforward, explaining my motives conversation to this person in my life? Was there some other, maybe motive here to take the heat off of other people? I mean, I think that those are legitimate types of concerns, but
the moment that I saw these text messages, I'm like, I feel like these were made up just to take in, obviously just speculation. And maybe I'm asking you to take your lawyer hat off for a minute, but it's like, it almost looks like these are made to prove the innocence of Twigs. That was my first time reading it. I'm like, oh, this is all contrived. I don't doubt that it's contrived. I just don't think it was contrived by the feds. And the other thing too, to me, if I was a fed and I'm like, hey, you know what? I want to create this conspiracy and I'm going to charge this guy and I'm going to make him, like, I don't think this is the vernacular that I would choose to do this. Like, it's almost so weird. Like, I don't know. There's that part of it. But what's your, just like Andrea Burkhart's thought on what is going on behind this? Pure speculation. Do you see any? What's your thoughts on that?
As far as the text messages go, yeah. I mean, I would not rule out, like you said, the possibility that this is some kind of trying to throw off the scent of other participants, other culprits, and things like that. So here's the thing where sometimes defense lawyering can get a little bit tricky, because if that's true, right, then my client did that because he does not want to implicate this other person, and so that's going to be very important to him. That's going to be part of his personal goal in all this. But the problem is that in terms of his interest in his self-interest in defending against this case, it's helpful to him anytime I can point the finger at other people and be like, no, that's the person who was like the real impetus behind it. This guy was just, my client was just, brainwashed, or he was manipulated, or he was caught up in something bigger, or he was blackmailed. I mean, just whatever, something that would diminish his personal culpability relative to some other accomplice, some other perpetrator. And, I'm going to be making sure my client understands, like, you want to protect this guy enough that it might cost you your life. Like, we could literally be paying the ultimate price in order to have that kind of protection. Is that really what you want? Because if he's involved, or if somebody else is involved, that might be something that we can use. If not, maybe to get you off, guilt-wise entirely, at least potentially as mitigation for why you shouldn't receive death for it. And it's, lawyers have different strategies with how they deal with their clients, how much they let the client drive the train, versus how much they make the decisions themselves. And there's a kind of a lot of different philosophies behind how that goes. From a legal standpoint, the general kind of cutoff between who gets to decide what is that the client gets to decide the objectives of the representation. Like, how are you pleading? Basically, they get to decide, I'm going to plead guilty, I'm going to plead not guilty. They get to decide, I'm going to testify, I'm not going to testify. And ultimately, like, that's most of it. that's most of what the client gets to decide. Everything that relates to trial strategy and how are we going to achieve this objective, the lawyer has the right under the law to decide that, even if the client disagrees. But the practical reality is that, you get crossways with what your client wants. It can make it very difficult to represent this person. You have to have, some trust, between you for that to go forward. So I can't project on Tyler Robinson's defense team and how they interact with him and how they would make those types of decisions. I can say for me personally, I have always seen it as primarily the defendant's case. And I will want to defer to their wishes about stuff like that. Now, I might CYA, 10 ways from from Sunday to make sure it's clear. We had this conversation and I said we could go down this road. And you said, Chris, you said absolutely do not do that. And here, sign on the dotted line to protect me for later on.
Well, let me ask you that. If you obviously have, attorney-client privilege, if you find out from your client that other people are also involved and have committed crime, do you have any legal obligation to let that be known? Or
no, absolutely not. No, that's confidential. Anything that is done in the past is confidential. If I have reason to believe that there's a future crime that's threatened, like there's some imminent harm, then I have a duty to disclose that. But no, past wrongdoing is like squarely within what gets protected by attorney-client privilege.
So even if you were sitting with Tyler Robinson, he said, you know what, Lance Twiggs helped me in X, Y, and Z, you wouldn't have a duty to disclose that.
No, absolutely not. And so the only complication that presents to me as a lawyer is it means I can't now go into court and contradict that. I can't go into court and put you on the stand and you now say Lance Twiggs had nothing to do with it. I can't suborn perjury from you. I have an ethical responsibility not to do that. And so there's kind of different schools about how to approach that too. Some lawyers will be like, I don't want to know anything from the client because it will limit my options when it comes to trial. If they've, gone on record with me about a particular fact, then that's what we're stuck with when we get to trial. And, that might make it harder to win. If that's like your main focus in the case is winning, then you might not want to do that. If you want to kind of focus a little bit more on, what is the truth and how can we help you kind of embrace that and live with that and deal with that and accept the consequences of that and so forth, then you're going to want to know with the understanding that, this is going to constrain your trial strategy later on.
Interesting. A lot of people criticize the FBI and Utah authorities for, not sharing more information. Everybody, I don't know, it's this weird thing where they want the authorities to prove the case to them before it even goes to trial. And, we have a constitution that's set up so that people aren't trialed in the eye of the public, but that's kind of what people want. Do you see anything strange in this case that regarding them not sharing more information or not sharing the information they are? One of the big things that's kind of made a big ado about, and I don't even understand why, is the missing footage from when Tyler supposedly turned himself into the sheriff's department. I don't even know why that's super relevant.
It's not. This is the product of the information vacuum. So a lot of this situation is, I think driven by what I was calling before, this entitlement to information on demand. We're so used to in the internet era, I want to know something, all I got to do is plug it in Google and I get to know like that. And of course, the court system doesn't operate like that. You actually have to have a little bit of patience and wait for things to happen on their own terms. And so one of the most important things that's going to happen in this case very soon is going to be the preliminary hearing. We just haven't had it yet because this is a death penalty case. And so they're being cautious. The defense has asked for more time. They want to review all the discovery, like a terabyte, it's a lot of information. And so it has not happened in the kind of quick time frame that it ordinarily would. But the preliminary hearing is the first real vetting of the evidence. And so, like I said, we have not actually seen any evidence in this case so far. We have seen descriptions of evidence. We've seen, allegations of what the evidence is, but actual evidence has not been presented in this court process at all. And the preliminary hearing is where that's going to happen. And so that's going to also presumably get us a little bit more up to speed with a lot of this stuff that has happened since the time of the arrest. The goal of the preliminary hearing is it's similar to the charging documents. It's to show that they have probable cause. But they need to substantiate their reasons for charging this as a death penalty case, the special allegation, the specific type of aggravated murder that they've alleged here. They're going to want to show as much context as they possibly can, and I think that's elevated in a case like this that has so much public attention. You got multiple things going on. You certainly have the court process, but you do have the court of public opinion and the fact that people are watching and they do want to know, and the participants are not blind to this at all. They know what conversations are out there, what kind of doubts that there are, and things like that. And so if I'm the prosecutor and I've developed my case, and I have lots of new information, I'm going to want to show all of that, to the public, because I'm going to want to assure them we haven't made a mistake here. There's not some, assassin still out there running around. We have the right guy. There's no mistake here. There's nothing to be concerned about. But for, whatever reason, we haven't had that patience really in the public square to just wait for the process to play out. It's taking time because Tyler Robinson has asked for it to take time. That's part of what is going to make it fair to him, because he has a right to challenge all of this stuff at the preliminary hearing. So he needs time to investigate it. He needs time to vet it. He might need to, bring in his own experts to review it and make sure that it's legit and it's on the up and up. He might need to plan his own testimony that he wants to present to try to undermine some of this evidence that they have. So it's like a little mini trial, but we're just not there yet. And so because we have this information vacuum, and the court process takes forever, and there's not really anything new coming out except for a lot of very interesting stuff to me about court transparency, but that's boring from a substance of the case standpoint. There's a hunger for anything new. And what you see in that situation is a lot of desperation to come up with something. So that's what I think this whole issue with, the missing video is. I mean, they have video of him in the station, in the interrogation room, the thing that actually matters. It seems that if anything is missing, it's literally just people walking into the station from the parking lot. And so what possible relevance that has, seems pretty minimal. I
haven't been able to figure it out, but I hear it talked about constantly as proof that this whole thing, is a big, Fed conspiracy. And then somehow, Israel's involved, the French assassins, all those things.
Well, video getting overwritten is one of the most common things that you run into as a defense lawyer. It can be a little bit frustrating, but the 30-day overwrite is routine. You kind of expect that. That's pretty normal. And so, ideally, what happens is police know what cameras are there. They know what they have footage of. They know what they need footage of. They know what's important. They know what actually, is going to bear on some fact that's at issue in the case. And so they go in and preserve that. But it doesn't mean they're going to keep absolutely everything. That would be insane from a, just management standpoint. I mean, should we have every single video, every hour of him in his cell and stuff like that? It's just, that's just not how things are done. It's,
yeah,
it's very normal for video to be lost because it got overwritten because it didn't matter to anything.
Well, and there's actually been reports now that they actually do have that video. They've actually
Mm.
classified it according to the state of Utah, and it's now part of the evidence, which
Mhm.
makes sense to me. But I don't know why. Like, okay, we lost it. Let's say we intentionally deleted it. I don't care. Like, how is that? That doesn't change anything here. But moving on a little bit, one of the things when I first got they first released the probable cause in these charging documents, the thing that stood out to me the most was on page 6, folks, if you're following along or whatever, but it said Robinson's mother stated the following to police on September 11th, the day after the shooting. Basically, Robinson's mother saw the photo, and then she actually shows the photo to her husband, and both of them say, hey, that looks like our son. So they call their son. They try to corroborate his story. He says he was sick today and the day before. Next thing you know, they're getting pictures of the firearm. The father's like, hey, where's this gun at? To me, like, out of all of this, as a parent, that was one of the most damning things, because, and you can tell me if this assumption of mine is wrong, if I'm reading this as a parent and this is all made up, like, there's nothing that would stop me from getting in front of a camera and be like, no, they're saying that I turned my son in. They're saying that I said all of this. It is not true. They're trying to railroad my son into a death penalty. Like, what's your thoughts on that portion of it possibly being, fabricated?
Yeah, I tend to agree. I think that's extremely unlikely. Which kind of takes us also to the gag order, the gag order that's in effect in this case, and it's kind of subject to all kinds of confusion. There's more litigation going on about it right now, as far as the scope of it. But it's just one of the most common questions that comes up when I talk about this case is, who does this gag order even apply to? What are the, potential consequences for it and things like that? And so I think it's really important to understand that this gag order applies only to the lawyers in the case. It does not apply to witnesses. It doesn't apply to anybody that potentially has information, anybody that's going to be potentially called, with the exception of law enforcement who are considered like agents of the prosecution. So there's nothing legally that prevents Tyler's family from saying, whatever they want about the case if they had the desire to do that. But that's I think maybe even an aside to your point, which is just, as a parent, would you even do that? That's exactly the reason why that particular part of the allegation is so incriminating. It is so damning, because you wouldn't expect parents to turn their kid in unless they really think there's something there. You would just, I see it all the time. Parents bend over backwards. There's like a massive amount of denial a lot of times with kids who are committing crimes, and parents just don't want to believe it. So to reach that point where not only do you believe it, but you're actually gonna like turn him over for the consequences.
And let's say that a bunch of this is fabricated, and it's, somebody decided they wanted to pin this on Tyler Robinson. Is that easily going to be disputed in court? For instance, let's say for whatever reason his parents have decided to stay quiet, but you know what, they didn't actually say that, or let's say they changed their minds. I don't know, which has been said. When they get, I'm assuming that his parents are going to be witnesses, and would there be anything that would able to stop the prosecution from, examining them, putting them on the witness stand, and or cross-examined by the defense, right? I mean, they're probably subpoenaed, right?
Oh, I would absolutely think so. They're percipient witnesses to a lot of this, and just to, again, the process of how he came to law enforcement's attention and came to be turned in at all. So yeah, they're absolutely going to be witnesses, and that gets to your question of how do you deal with the possibility that the stuff is fabricated? Well, there's going to be a lot of witnesses to talk about it. Kind of similarly to like this missing video, right? Okay, if this missing video is significant, there's at least 4 witnesses there: Tyler's mom, Tyler's dad, Tyler's family friend, who are going to be able to tell us that there is a problem here with how this is being described, how it's being characterized, and so forth. So that's kind of always the backstop that you have, is the ability to just go straight to the people that witness these events and get their take on it.
Yeah, so right here on these, we have this narrative that's being put out. It's clearly I guess it's not testimony. I don't know what you would call this. It's just explaining what the parents have said, right? Now, when it says Robinson's mother stated the following, whatever, everything that the father stated, all that stuff, will that stuff be recorded? I guess is my question.
I would expect so. But it's one of those issues where practices can vary. A lot depends on, maybe, do they have body cams in this particular jurisdiction? A lot of places, it's not universal. Maybe, could argue about if it should be or not, but there's still places that don't have body cams. If you got body cams, you're far more likely to have a lot of stuff on, recorded. If this conversation is taking place in the station, in the interrogation room, then again, you would expect it to be recorded. But it's not unheard of, especially in smaller departments, places that maybe aren't so well funded, don't have all the equipment and the cutting edge technologies and things like that. It's not that uncommon still for interviews to not be recorded, to just be witnessed by the police officer, and then you are banking on the weight of that police officer's credibility. And if they took contemporaneous notes, having those to kind of corroborate it. So it's an I don't know. I would expect it, and I would certainly hope so, but it's possible that it's not.
Interesting. Yesterday in our interview, Erica Kirk talked about having meetings with attorneys and prosecutors. And a lot of people made a big deal about that. Like, oh, why are they meeting with the attorneys and prosecutors? And is that odd or strange or anything like that?
Not remotely. She's the victim of a crime. In pretty much every jurisdiction in the country now, victims have rights protected by the law. Now, none of these give them the right to have inside information or investigative information or anything like that from law enforcement. And there are certainly cases where, entrusting families, survivors, victims, and so forth with inside information would be imprudent. It wouldn't be a good idea. But they're very cognizant of the fact that they're dealing with the victim, and they're trying to do that sensitively, and they're trying to do that in a way that provides some comfort to that person. I mean, this is one of the things about the role of law enforcement that I think, I'm a defense lawyer. You might think I'm like knee-jerk anti-cop. I'm not at all. I'm anti-bad cop. Like, everybody hates bad cops. But good cops are such an important part of our society, and just being able to have a cohesive.
You're not anti-cop. You're just pro-criminal. I'm just joking.
I'm anti-government. Let's just say I don't like government power. I don't like these fascists coming and putting their boot on my neck. Okay.
I'm with you. We are
But so, they are often, dealing with the weight of the people who were victimized by crime in a way that, I, the defense lawyer, don't have to do that. That's not my client. I got to deal with it when I have to, cross-examine them or whatever. But so, cops and prosecutors and so forth, they can be very protective of the victims, very, very concerned about them. And so if they, think that if they have reason to think that this person can be trusted with some of the details that maybe the rest of us don't need to get. I'm not going to say that happens every day, but I'm also not going to say that it's super unusual, it's unprecedented or anything like that, because it really isn't.
Yeah. There's another question I had on the tip of my tongue, but I forgot. Let's do this. Anything else that you can think of, major key points, before we bring in the chat and have them start asking some questions about this that maybe you find? I know what I was going to ask you. When when they are meeting with the victims, like, they're having these meetings with Eric Kirk and things like that. Now, are they just kind of keeping them abreast of what's going on? Is it sometimes the prosecutors are, getting additional information where there might be some information gaps? What are those types of meetings? What do they normally entail?
Yeah, I mean, there's a lot of different things that can go on in these types of meetings. Sometimes it is just going to be procedural. Here's what's going on. Here's what the next step is going to be. Here's what you can expect is going to happen. Erica's, likely to be a witness herself, even though she wasn't there, at the time. She's a surviving spouse. She's got insight into kind of his final moments and the day, the context leading into the circumstance happened. She's obviously going to be a witness in the if there is a penalty phase, if he's convicted and they go to penalty, because she's the primary victim. She and the children are the primary victims of the crime, and so the effect on them is an important part of that court process. So some of that can just be like procedural. Here's what to expect, when to expect. Here's what that's going to be like. Some of it can be substantive. Hey, we got new information. Maybe there's questions that they have for her, like who should we talk to about X, Y, and Z? She's, in addition to being the victim, also the CEO of TPUSA. So to the extent that there are people at TPUSA that have information, that have evidence and things like that, she's going to likely be their point of contact for like, who should I talk to if I need, this video or that communication or things like that. And some of it can also, frankly, just be, touching base, just checking in. How are you doing? Doing okay. I haven't forgotten about you. It's a really kind of understated and maybe underappreciated part of the criminal justice system, is that part of the reason we have it at all is to, vindicate the rights of the people that have been victims, that have been victimized by crime, and to, just acknowledge that what they are going through matters. Their pain matters. It's not right. We're trying to do something about it. We care. And so some of those outreach points can just literally be as simple as that.
Interesting. So as I understand it right now, Tyler Robinson has pleaded not guilty. Is that anything kind of send off alarm bells for you on that? I mean, I have my barracks lawyer thought on it, but I'm curious what you would say with that.
Well, what I say is, technically speaking, he has not actually pled guilty, not guilty yet, because that won't be until after the preliminary hearing. He hasn't been bound over on the charge at this point. So they'll have the preliminary hearing, and then assuming that the court finds that there's probable cause for him to be bound over, then he'll be arraigned and he'll be asked to enter a plea at that point in time. Now, is there anything alarming about him pleading not guilty? Absolutely not. It is routine. It is knee jerk. It is what you do, 99% of the time. It's certainly what you're going to do in a death penalty case, unless there's just extraordinary circumstances where you have been able to, work out some kind of negotiation ahead of time, but that's clearly not the case here. So no, that is just, it's pro forma. It's part of the process. It's what you do to maintain your rights. The state has to prove it. And so if you don't hold them to their burden, then you're just giving them heard, whatever they want.
I've heard online though, that means he didn't do it. That's what I've heard.
It might, but it might not.
Yeah, sure.
People plead not guilty when they are in fact guilty all the time. It's because it's just part of the process.
Last couple of questions before we get to some questions from the folks out there and reading your comments and stuff like that. And again, we will prioritize super chats. We'll try to get to as many other ones as we can. Do you think that this is going to go to trial?
I think it's really difficult to say at this point in time, because there's so many moving pieces that we don't know. We don't know how strong the case actually is. We haven't, like I said, we haven't seen any of it really. And the glimpse that we've gotten is really just a drop in the bucket. I think we'll have a much better idea after the preliminary hearing, how solid is this? How many holes are there, left for the defense to be able to exploit? there's also how amenable is the prosecution to cutting a deal. If the prosecution is saying, absolutely no way, no how, we're not taking the death penalty off the table, then you don't have any incentive to plead. So you might as well, take it to the wall and make them prove it. So those are just factors that we aren't going to get to see, and they're pretty critical for predicting what that outcome is going to be.
Given how much evidence there is, and obviously, just like you said, we got to see the evidence, and obviously the defense is going through the evidence, and it was the defense that asked for a 2-month extension because it was so voluminous, the amount of evidence that they had to go through. So I think that actual hearing is going to be mid-January.
So it hasn't been set yet. We're going to come back in mid-January, I believe, to check back in and set the date for the preliminary hearing. But when it's actually going to be, we still don't know. But it should be, I would think, early in the new year.
Now, there's supposed to be, I believe it's December 15th, is going to be some sort of hearing. What is that about?
So it's tomorrow. It's actually tomorrow. I'm gonna be live streaming it. It's at 12 Mountain Time, which is 11 o'clock my time over here on the West Coast, and 1 o'clock over there where you are. And so this is not going to be real compelling from a substantive, we're not going to likely learn much, if anything, about the evidence, the case for guilt or innocence or anything like that. But these are the hearings. This hearing is related to what we are allowed to see as part of the court process. So this is something that is kind of near and dear to my heart, because I'm a major advocate for court transparency. I learned this from Depp versus Heard. You cannot trust what the media says about a case, not just because there's the whole there's just often a narrative, that's promoted that is not really a fair and truthful depiction of what is going on. But also just because the media often that's covering these cases, they aren't legally educated. They don't know what matters or not. They don't really understand what it is that they're seeing. So it's rife with inaccuracy a lot of the time. So it's very important for us, we the public, to be able to see with our own eyes what is going on with the courtroom. This is a right that is grounded in the First Amendment, right? We have the right to monitor our government and make sure that it's functioning the way that we expect it to function. We don't want presumably, we don't want the courts railroading people without evidence. We don't want them cutting sweetheart deals for their good friends who are doing bad things and getting away with it. So court transparency is a critical part of being able to maintain the integrity and the legitimacy of the institution. As soon as you put it behind closed doors, you have reason to distrust it. So there's been a lot of threats, I guess, to court transparency in high-profile cases around the country. It's just kind of becoming this increasing phenomenon where there's gag orders, there's things that are being filed under seal that we don't get to see, hearings that are closed to the public, and there's been little hints of that in Tyler Robinson's case, but not nearly as bad as I've seen in some other cases. Certainly the Richard Allen cases in Indiana is by far the worst of those that I've seen. But they have, had some sealed documents, some hearings closed. But on the other hand, they've had cameras there, routinely, and we continue to see these requests for the hearings to be televised coming through. They're approved. It hasn't really seemed to be that much of an issue.
What would be the defense? Because I've heard reports that the defense doesn't want the case televised either. So what would be the defense's why? What would their motive to try to not have the court case televised?
Well, because it's not going to be helpful to them. What people see, it's not going to favor the defense case. If it was going to favor the defense case, they would want to shout it from the rooftops and have it spread far and wide, have it broadcast on every channel. So, I mean, there is a little bit of an implicit wink there that you can take away. from the fact that no, the defense doesn't want us seeing this stuff because they don't want us prejudging the case. Why? Because what we see is going to be bad. It is going to, it's going to make us think that Tyler Robinson is guilty, and they, understandably don't want to have to deal with a jury pool of people coming in who already, have formed an opinion about the case before they've heard the defense side of things. So, I mean, it just tells you a lot, about who is kind of holding the cards, who's in the position of strength based on who wants you to see what's happening and who doesn't. I think a real big tell in this is going to be, this preliminary hearing, like I've said, is the first major vetting presentation of the evidence that we're going to get. It will be open to the public. Again, this is constitutional magnitude stuff. Probably going to be televised as well, given the practice that the court has shown so far. But the defense can waive it. The defense has the right to waive it. It's not something that is necessarily required to be held. There is a little bit of a nuance in Utah law where it's not entirely clear if they have the power to make it go away altogether, or if the prosecutor also has to buy in to not putting on their case in the preliminary hearing. But that would be a big tell in my perspective. If they didn't want that hearing to go forward, it's because they don't want the evidence to be publicly available. They don't want us to be seeing it at this point in time. There's just so many strategic advantages that the defense gets by having a hearing like this. You get the preview of their case. You get a free questioning of their witnesses. You get to feel them all out. You get to see how do these people respond under fire? Who's the difficult one to deal with? Who's going to be the easy one that I'm going to want to try to, do more of my questioning with this one because he's compliant and he'll give me, whatever information I'm looking for. So many advantages to having the preliminary hearing that if it were waived, it would to me be a huge tell. That you're giving up, that the trade-off is worth that much to you, to not have that opportunity.
Now, even if, let's say, they don't have a trial, would you expect them, if they don't have a trial, would they release all the evidence? How does that work? Because I know there's going to be a lot of people that, like you talked about, transparency, that want to see the evidence, all those things.
Well, it does get complicated if there is a guilty plea, because then you start to get into public records laws, Public Records Act kinds of territory. And in this situation, you'd have a whole bunch of different kind of baskets that's in, because we have the FBI, we have federal, investigations involved in this. And so they have their own standards of what they will produce, when they will produce it, under what circumstances, and so forth. And then the state will have their own system of what do they have, what will they produce, what will they not produce. So it's very probably universal at this point with public records laws that they all have an exemption for ongoing investigations or things that could jeopardize an upcoming trial or a pending trial. And there's a lot of litigation all over the country, all these different states, about does that exemption survive the case being closed, a case concluding with a guilty plea or a conviction or something like that. Federal law on this is not favorable. They basically will say, doesn't necessarily mean that every investigative interest of all types is mitigated or is satisfied just because this particular case is over. Maybe it spins off into other investigations. Maybe there's so much in here that reveals secret techniques and methods, investigative methods, maybe sources, stuff like that we don't want to jeopardize. So the federal law on this tends to be much more favorable if they don't want to turn stuff over. State laws just really vary. This isn't something I've looked at in depth in Utah, so I really don't know if Utah state officials would local police and all those would release a lot of their records. Some jurisdictions will, some won't.
Would you be able to FOIA that information? How does that
That's
work?
what we're talking about. Yeah, that's what we're talking about. So FOIA to the federal government is always you might as well consider it like you're petitioning the king. Okay, it's entirely up to him. And you may or may not get any like satisfactory explanation for whether you're going to get answers or not. This particular administration and their connection to this particular crime, they have relationships with Charlie Kirk and with Erica and so forth. That might play in. I mean, I would kind of expect that it would to some extent. But there really is no way to know. There's no like black and white law out there that says, yes, they have to turn this over at this time or whatever. It's very, very discretionary.
Last question on this. When do you think, like realistic, if we have a trial, if he doesn't figure this out, when do you think, what are we looking at as far as a timeline, do you think, before we actually have that trial?
2027.
Wow. So
yeah, at least maybe late 2027.
Wow. So, I mean, potentially we could have a completely different administration in there by the time it's all said and done.
I mean, not impossible. I think it's probably gonna go forward before that. But yeah, it's just, again, because this is a death penalty case, they are always extremely cautious, and so because they don't want it coming back, they don't want to have to redo stuff on appeal, so they don't want arguments that the defense has been ineffective because they didn't pursue a particular investigative avenue, they didn't have time to talk to everybody, they didn't get the experts they needed to be able to vet the state's case. And so the review of the state's evidence is itself just extremely comprehensive. But then there's also just whatever independent investigation the defense needs to do. And this is above and beyond investigating guilt or innocence for the crime. With the death penalty case, you have responsibilities to investigate mitigation evidence, meaning like you got to get as much information you can about this guy's entire life history. You want to be talking to his kindergarten teacher. You want to be talking to his best friend when he was 4 years old. Like, you want to get absolutely everything you can so that you're in a position to present a full picture of who this person is and, why, in the defense view, he is not the worst of the worst. He's not somebody that should be subjected to the death penalty, even if he did, commit this particular crime. He should receive mercy for whatever reason.
So, I mean, even though we have the charging documents and all this stuff, like the investigation is still extremely intensively underway. Like, they didn't just stop.
Yeah, I would absolutely expect so.
So there's not just only one podcaster that's investigating this still. Is that what you're telling me?
The FBI is almost certainly still investigating this. If nothing else, the CAST team is going to be involved with this. The CAST team is who does the location analysis based on cellular data. Absolutely expect that type of thing to be happening in this case. I expect geofence warrants in this case. I expect just a lot of forensic investigation. We know, at least, anecdotally or through the rumor mill or whatever, maybe just with our common sense, because we're talking about, Gen Z guy. He's online. He's got an online footprint. So there's a lot there to sort through. There's contacts there to try to reach and try to interview people in his day-to-day life. They're going to want to be interviewing, again, like the people, if they can identify people who were present, like maybe in the stairwell, maybe who, passed him on the way in, anything like that. A lot of follow-up of that type of information is going to be going on as well. So yeah, I mean, I would fully expect going to be a still very, very active investigation.
The one of the other things that's been brought up, and people have had a lot of consternation with. So, Charlie unfortunately was killed on the 10th. The FBI and Utah State basically had the entire campus locked down from the evening of the 10th, the 11th, the 12th, and the 13th. So they basically had 3.5 days. And I did talk to people on the ground there. Like, there were people there forensically processing that place 24/7 for those 3 days. And I don't know if it was an exaggeration, but the word that was used with me was there was hundreds of people there during those 2 days. And then, of course, they conclude that on late Saturday. And of course, on the 14th, that Sunday, they paved over that area. They used pavers to recondition that area. Number one, those 3 days to process that location as a defense attorney, do you find that weird? And then do you have any concerns about them paving over the area where Charlie was killed, where, there was a lot of blood on the ground and things like that? Anyways, what are your concerns about that whole situation?
Yeah. So the 3 days doesn't really catch my attention too much for a crime like this. They're going to be doing a lot of different things that they're going to be looking for. They're looking for trace evidence. They're looking for blood evidence. They're looking for DNA evidence. They're looking for things that we saw, with patterns, things like footprints and, the arm print and stuff like that. There's going to be a lot of just recreation with the camera, the surveillance system, and all that type of thing. So it's a fair amount of stuff to be looking for and trying to get through.
You don't. I mean, basically, the allegation is that's not enough time for that whole area, and then of course, then it's like the allegation also is they covered up the crime scene when they put the pavers down. That's the other allegation. Defense attorney, would you see problems with that?
Well, I don't love that. I mean, I can't lie about that. I don't love that at all. If I'm the defense attorney, I want to have as much evidence preserved as possible for me to be able to go in and independently do my analysis of it, do my research, and have my own experts come out and do their own forensics and so forth. So I definitely don't love that. But again, it's not entirely unheard of. We had that whole situation in the Koberger case where the house was torn down. And so there's a little bit of an intersection here between, people do have property rights. Like this does belong to somebody. They do, have their own right to make some kinds of decisions about what's going to be done with it. And if you don't want this house associated with this murder being like a tourism spot for for true crime people, you do kind of have the right to tear it down. But at the same time, in that case, they were really cautious about making sure that the defense had access to it, that they had plenty of time to go through it, do their own stuff before they made the decision, to tear it down. They kind of cleared with everybody, hey, there's nothing else you need here. There's nothing else of value. So that would have, from my perspective, very much been preferred in this situation, because it does give the defense something to argue. They're like, hey, you destroyed this. You put this in a situation where we aren't able to go in and independently verify whether these things were done correctly, whether it is, documented the way that you documented. We have to kind of take things on faith. So some of that, is just going to depend on how good of a job they did. Like there's going to be a gazillion photographs, of this scene, like everywhere. With the FBI.
Let me rephrase that question a little bit. Is there a reasonable explanation as to why they did that? From it, or as a defense attorney, are you just like, you destroyed the crime scene? Like, is there a reasonable explanation for that, I guess?
Well, I would be asking, what is your reason? What was the necessity to do this? Because there's always trade-offs, right? There's always trade-offs. And, so crime scenes can be biohazards, for example. Like, I don't necessarily want to maintain a biohazard. I might want to do something to remediate that situation. That's extremely common. Crimes happen in like rental properties, and the landlord doesn't want to be stuck with this crime scene for 2 years until the case gets to trial. Pretty normal. You come in, you get the evidence that you need, you release it back to the owner, and the owner, does whatever they need to do to get it back into usable condition. So it's not unusual for there to be things like that, or for there to be reasons like that. But I also don't think it's unreasonable for the defense to be asking,
sure,
what was your reason for this? Why the rush? Why the rush?
Yeah. Fair enough. All right, folks, what I'm going to do right now is I'm going to go to Twitter. The other day, I asked you guys to provide some questions, and we were going to go through these. Some of these are off topic, so I'm not going to ask those, or they're redundant. Let's see. Andy Lou says, how should the defense attack the prosecution when it in the charging document says, oh, I already covered this. He got this. So this is one of the things, folks. There's a lot of confusion out there. And I'll state this. Andy says, how should the defense attack the prosecution when it in the charging document says TR was out of camera view when the shot rang out? As we all, the defense knows, the shooting position was in view of the camera. And I said, I'll bring this up, but this is what's in the charging document. I said, that's not what's in the charging document. Because what is in the charging document is, although the individual moved out of the camera's view for a short time, the camera again captured the individual running across the roof, then low crawling to the area where the UVU officer recognized as where the suspected sniper had dropped into a prone shooting position. After a short time, which makes the known time of the shot, the individual arose and ran across the roof to the northeast. So I see like 20 of these every day where people are still a little confused. They got some, and there's a lot going on with this, and there's a lot of new information coming out. So I get it, but just understand that, if you go to the charging documents, you can get kind of squared away to know what the actual facts are of the case, or at least the alleged facts of the case.
And if I can plug real fast too, if folks want to go to my Substack, I am maintaining a public archive of the legal documents that I'm collecting in this case. So it's the first thing that you'll find if you go on my page. It's up at the top. You don't have to subscribe or pay money or anything like that. It's not paywalled. It's there for
folks. Support this lady.
There for transparency purposes, so people can know, because I personally believe nobody should have to pay for access to the law, even though the reality is that, like, yes, you always have to pay for court documents and stuff like that, but we shouldn't all have to feed into that behemoth. So anyway, the information is there, the probable cause affidavit is there, everything that I have looked through that looks to me like it is meaningful in some way. I buy it, I put it up there. So it's available. You can, read a significant chunk of the court file over there.
Yeah. Go check that out, and definitely support her, folks. Amatak, whatever that is. Is there a foreseeable, well, he's talking about Candace and repercussions towards, is she covered under the gag order? You already covered that Candace and other people, basically anyone outside of just the prosecution and the attorneys, those are the only ones covered under the gag order, right?
Yes. So that is currently under litigation. The way that the gag order currently reads is that the lawyers for the parties are prohibited from making, their extrajudicial statements. And they're also supposed to make reasonable efforts to prevent people that might be associated with them, their team members, their witnesses, and so forth. They're supposed to try to get, those people to also not make prejudicial statements. But that is it's a little bit difficult for just kind of random people that have information, because I'm a lawyer. I don't have any power to shut somebody up if they want to say something. If I'm like contracting with an investigator or something like that, I can put an NDA in our contract, so I can try to shut you up that way. But the actual reach of it for practical and some legal purposes is to the attorneys and to their immediate teams. Now, the prosecution has filed an objection to the gag order just as it currently stands, which I tend to be sympathetic to. I did a review of the gag order over on my YouTube channel when it was kind of first out, because this again is starting to become a little bit routine in these high profile cases. There's quite a bit of case law on the First Amendment and the court's power to shut people up, and how limited that power actually is, and what kinds of steps really need to be taken, findings need to be made before that type of thing can be justified. So the state is kind of arguing that this needs to be narrowed, given those First Amendment limitations. The defense has come around and said, not only do we think you shouldn't narrow it, but we are going to be asking you to expand it. We're going to want you to cover more people. We're going to want you to try to gag, like politicians. They seem to clearly be thinking about like Pam Bondi and maybe even the president. I have no idea what the defense's theory is going to be for how a small state court judge in Utah is going to have like jurisdiction over what Pam Bondi says. There's like so many supremacy clause issues with this very idea, but they put it out there. They've announced that that's their intention. So I am awaiting their argument. So there may be some flexibility with where the gag order ends up going, but yes, as far as where it is right now, technically it applies only to the lawyers and the immediate like law enforcement investigators on the team.
Interesting. He also asked, is TR receiving due process? What type of, did he have legal counsel at the time of surrender, and does it matter? And do you think he's receiving due process?
Yeah, I think he's receiving due process. He's got an outstanding, highly qualified defense team. They're all, very accomplished. They're all, a lot of experience in capital defense, particularly, which does tend to be its own animal. So he's getting a lot of the benefit of things like we talked about. He wants time before going to the to the preliminary hearing because there's a lot of evidence to review. He has an opportunity. He has a right, to be prepared. It's supposed to be like a meaningful opportunity for him to participate in challenging the state's evidence. So they're giving him, every opportunity to do that. The court, I think, has been especially cautious. We're starting to see this greater trend now in the cases that get a lot of public attention with letting them show up in civilian clothing. That's going to be one of the things tomorrow. Tyler will be appearing in person tomorrow. It's going to be the first time that we have eyes on him since, that very, very preliminary one when he first landed in jail in the turtle suit and all that. So he'll be in the court. He'll be in his civilian clothing. That is a courtesy that the court has no duty to extend. But again, I think they're being careful to try to not be unduly prejudicial to him. So yeah, I see him receiving due process so far. As far as him being represented at the time he turned himself in, we have no information that he was or wasn't. He has a right to, but you have to exercise the right. It's not something that's just kind of like automatic. Anytime you're suspected of a crime, you have to have a lawyer before anything can happen. You have to invoke your right. You have to exercise your right. There is some implication in just what we've learned, about the case and from the probable cause and so forth, that he didn't necessarily speak, to law enforcement. We haven't heard about a confession or anything like that. So either that's because he invoked his right to counsel or invoked his right to silence, just chose not to do that. Those are all protections that he has that he seems to have been abundantly afforded.
Yeah. Disillusion says, has there been any evidence or testimony about where Tyler practiced with his weapon? What I will say is I do know in the charging documents, it was said that they found shot targets that have been fired at in his apartment, but I don't, Andrew, do you have anything to add? Does it say or you have any information that says where he may have practiced?
No, nothing like that at this point in time. And that's exactly the type of thing, like I said, I'd expect them to be, doing their investigation into. They're going to want to know exactly, what his daily habits are, where he goes. They're going to be trying to watch him, trace him, get that type of information nailed down.
The last one that we'll do from X says, can Tyler claim diminished capacity because he is in the furry community, thereby claiming some form of mental illness and try to end up in the institution instead of a prison?
He might. I mean, there is insanity. There is diminished capacity. Insanity is, very, very difficult in most jurisdictions to be able to pull that off because it basically says you're not guilty. Sometimes that's all you got in a case. If it's really clear you did it and they're going to be able to prove you did it and there's no credible way for you to argue to a jury that you didn't do it, you need to come up with something credible, or you're just, you're going to be out of luck with this process. And so I would fully expect them to have already started investigating that. It would be, from my perspective, one of the very first things that you would do in a capital defense case is get a psychological examination of your client. And that's both just to get a feel for, are there any psychological defenses that we can potentially raise? It's extremely important in death penalty because it's going to go again to mitigation. If you're less culpable because, you're psychotic or something like that, it's, you're just maybe not necessarily as egregious as somebody who is just a cold-hearted killer or something like that. But also the competency to stand trial. It can be a very important issue. If somebody is, they're just completely out of it, or maybe they're like so depressed that they shut down, and can't meaningfully work with you, then that calls into question whether this is, if they can't participate in the process, is this a fair process? So I would expect this to be absolutely one of the first things that they're looking at.
You got a fan here, Andrea. I mean, I may or not be hoping the kittens crash the show.
So, I fed the kittens right before I went on here, and their routine is they eat and then they sleep. And so I don't know if we're going to get a visit, but we'll see.
Fair enough. Now, this is a great question. Biggest question for me: how often do you find that meaningful evidence in the charging documents turns out later to be false?
It's not unheard of. I would say that it's rare for physical evidence, for digital evidence, for things that are material to turn out to be false. Again, not like completely impossible, but it's just less common because it's going to be more easy to detect. What's far more common is that people's accounts change, people's testimony change, people's memories change, people's motivations change. So the human element of a case is often very plastic, but the physical evidence side of things turning out to be wrong, not really that common.
Awesome. Chroma Dental says, thank you for being my daily dose of sanity. Keep doing what you're doing. We will keep doing what we're doing. Thank you very much. Great work, Gary. Defense attorney would know. You will find all this out in trial, not going to get autopsy report, video, bullets, frags until the trial. So he's
might get some at the preliminary hearing, but
awesome.
Stay tuned for that. Yeah. We're not going to get it until it's that time in the court process for sure. And we have not reached that point in the court process. You're absolutely right about that.
Awesome. What if he left the barrel on the roof beforehand and brought the stock with him? That may explain the screwdriver was found on the roof.
They're going to be able to trace his movements in all likelihood. If they've got his phone, they have his location, and he seems to be kind of unaware that your phone does leave evidence like that, if we're to believe the texts and that the text messages are from him. One of the comments he made about going back to recover the gun is, as long as he can get the gun, then he hasn't left any evidence. He's not aware of a digital footprint. And so if he's not aware of that, he's probably not thinking about things like maybe leave your phone at home when you commit your crimes, or you commit your preparation and your planning and so forth. So if he's got prior visits to the scene, I think there's a pretty good chance that they're going to be able to substantiate that.
That's right, folks. If you're going to commit crimes, you got to use a Faraday bag. I'm not saying we sell those, but we sell those. Faraday bags are great. Was it wrong? This is a great question. There's been a lot of talk about this on the interwebs. Was it wrong for the videographer to secure the SD card and the camera? Should he have left it in the camera? Does it make the evidence inadmissible? bothers many on X. Was he tampering with evidence when he did that, in your opinion?
I mean, physically removing it, if he's not like trying to destroy it or trying to conceal it or something like that, then no, he's not tampering with evidence. It is his property, and until law enforcement seizes it, legally and secures it, either because they have a warrant for it, that's a judge saying you're required to turn this over to me, or what happens far more often in a case like this where you have cooperative witnesses, they just agree to give it to you. He has the right to do whatever he wants with it. So it's not a legal problem in that sense. Where the issue, if there is any issue with this at all, comes up is with the chain of custody. The fact that he took it into his possession, didn't leave it in the camera, does that pose any sort of risk to the integrity of what is on that disc? I don't know offhand of any way that it would. I mean, if he's downloading it, editing it, I mean, whatever, there's going to be a digital record in the file, in the metadata associated, with the file. So again, most of this stuff in the digital arena can be accounted for, if there's any type of issue like that.
So that guy, so he by securing that, he did not commit a crime.
No.
Okay.
No.
Gary, in the charge document, page 4, UVU surveillance, it never claims that the suspect took the shot, only that he was in the shooting position, then states after the shot. Shouldn't they allege flat out that they observed the shot? I don't think they could observe the shot from that camera. We already see how digitally zoomed in it is where that camera is, and having been there and seen that camera, like it's cropping way in the nearest building. I think they absolutely could see him, but I don't think there's enough clarity or fidelity on that camera to be able to tell that a shot was taken. But he's at the right time, at the right place, doing all the things that I think most reasonable people on a jury would say that guy's getting in a position to take a shot. And what's your thoughts on that, Andrea?
So here's the thing with this case, and like the asking questions and so forth. As I pointed out, I certainly have some questions myself. And there's nothing inherently wrong with looking for alternative explanations or alternative theories or anything like that. I think the challenge becomes, though, that if you're going to propose some other theory of the crime, it has to account for all of the known facts, not just like the new ones, that you're looking at. And so there are some very bad facts here with respect to Tyler Robinson that your theory has to account for. You need to account for, why did he drive the 4 hours from St. George up to Provo at this particular location? Why did he bring the gun with him? Why does his, if his time is going to correspond with his cell data and so forth, why does he correspond with the movements of this person on the camera? Why is he in this position at exactly the time that we are expecting a shot to be taken from, roughly this angle? Why is he sending the text messages to Lance where he's saying he did it? Why is he planting the note ahead of time under the keyboard? Like, your theory has to account for all of the information, not just pieces that you can cherry pick out to point it at potentially other things. So why is his DNA like all over everything? It's all over the gun. It's on the shell casings. It's why does he have engraved, engraving stuff back at his house with other cartridges and things like that? Like, there's just an awful lot of coincidences that you would have to account for and like explain away, because it sure looks an awful lot like Tyler Robinson was the shooter. It sure looks like he did all of these things kind of his own accord, voluntarily. He's not on video like at gunpoint, being forced to do it or anything like that.
That's one of the things that's been kind of surprising to me in this is like, okay, we can say that the government's lying. Like you said, I don't trust the government. I always want to double check the government to see if I can find out they're lying. I want to hold them accountable. But the government lies. The government commits conspiracies. Those are facts. But you know who else commits conspiracy and lies is social media. And it's like, because you want to reject the government, the official narrative so bad, you're willing to accept other theories that have 1/10, 1/100th of the evidence or no evidence at all. And then on top of that, there's a lot of evidence against those other theories. But because I have this aversion to the government narrative, I'm going to accept something that has less foundation of evidence, facts, logic, or anything else, and accept something that's made up whole cloth. And it's a real problem in our society, and it is our government's fault. I mean, you know, but I do think people are exploiting there's a lot of people exploiting that distrust. And, you know, that could be political actors, that could just be social media grifters, it could be foreign adversaries. I think all those three things are involved in all this, unfortunately.
Yeah, and I have to say it's really not unique to this case either. Like it happens a lot. We saw one thing that we can, I think, be grateful for in this particular case relative to, for example, the Kohberger case. In the Kohberger case, there was a massive amount of disinformation that was being put out through the media, often attributed to like anonymous law enforcement sources and things like that. And much of this information turned out to be untrue. Like they had to have a whole court hearing, you know, about changing the venue of the case and like going on record. These things are out there. It's not true. It's not true that he stalked the victims. It's not true that he had their driver's licenses, you know, in a box in his home. Like all of these things are just kind of being put out there as facts about the case. And it's completely not true. So in this case, we don't really have that. We've got a lot of this like theorizing and speculating and things like that. And, you know, we can, it's just, we can argue all day about like how much weight that has and the value it has and so forth. At the end of the day, you know, people can believe whatever they want, but it's going to be grounded in evidence or it isn't. And, it just brings me back to there's a lot of facts here that really have to be accounted for if we're going to try to write Tyler Robinson out of the story of the shooting and what happened to Charlie Kirk. There's a lot of stuff here that needs to be explained for how that could coexist with a theory of an alternate perpetrator.
Oh, that's a great point. Pappy 1144 says, law enforcement going to risk their pensions, arrests, prison time to falsify evidence, and for what reason? If the FBI filed the charging documents, then maybe, but the local PD, far-fetched. What's your thoughts on that?
You know, I'm not going to say that law enforcement never falsifies things. Sure. It certainly happens, and certainly local police. I've told stories on my own channel about you know, bad cops. I don't know this department. I don't know the culture of this department. Culture of the department can be huge. Some places, you know, do have a lot more integrity and they expect that and they enforce it. Some places like, hey, maybe over there in Canton, Massachusetts, they're a little bit more loosey-goosey. Sorry, that was a reference to, you know, maybe if there's folks here from my channel, the Karen Reed trial, you know, it's very strong indications of massive, widespread corruption, boys club, you know, animals being more equal than the other animals type of scenario. So just a lot of that stuff can vary. I'm not going to say police officers never falsify things, but I'm going to say if they falsified the things that they are kind of being accused of falsifying, like the text messages, it's going to be easily verifiable. It's going to be easily discoverable. And they're going to know that because they're going to know what all of these forensic tools and opportunities and so forth are.
Yeah, I mean, it's a falsified many of the things in the charging documents, never mind the other evidence that we're going to come across. I mean, you're talking about the FBI would have to be involved, the parents would have to be involved. I mean, the whole litany of both local, state, and federal investigators that were in it, the different crime labs that were in it, the DNA crime labs, like there's a lot of people involved here that would have to be implicated in this huge cover up. I don't know. That's my take on it. Um, uh, we covered this. If he takes a plea deal, will we ever be able to see the evidence? Maybe, maybe not.
Mm-hmm.
Opinions on how much shows like Candace Owens can taint jury pool, and would that be asked during the jury selection?
Yeah, it definitely is something that that they can, and that's sort of presumed to be the first line of defense against bad publicity or prejudicial publicity in the case. Is just you talk to the jurors about it, about what they know and about how it's affected them. Sometimes you can, like in Koberger, they did a whole pretrial survey. They just like randomly surveyed people who would qualify for jury duty, asked them whole series of questions about, things that they had been exposed to or not, and then their opinions about the case, the opinions that they formed. So sometimes you can do kind of pretrial investigations like that. But I think the thing that often happens with publicity is that there's an overestimation of how far it reaches and how many people like are paying attention. The reality is that the people who are interested in the minute details of, criminal cases are not a majority of the population. It's a niche thing. There is going to be a niche that knows absolutely everything about everything, but that's not going to be your whole jury pool. There's going to be a significant chunk of people who don't pay any attention to it at all because they don't care about crimes. That's not what they're focused on. So they might know Charlie Kirk got shot, and that's about it. And there might be just a whole spectrum of exposure in between. So the fact that there is publicity and conversation and so forth in and of itself doesn't mean that anybody is being prejudiced in their right to a fair trial. It doesn't inherently mean that the jury pool is being tainted. It certainly increases the risk, and it's something to be aware of and to prepare for. But yeah, this is not the first case this has ever happened in. This is not the first time the courts have ever dealt with it. I mean, the big cases about pretrial publicity from the U.S. Supreme Court start back in maybe the 1930s, 1940s. I mean, the Lindbergh baby was a huge, massive case. Sacco and Vanzetti was a massive publicity with this prosecution. So courts have been dealing with this issue for a long time.
Awesome. Robert Roldan said, and I want to throw his comment up here because I think it's kind of a great example of a lot of what we see in a lot of, I don't know. He says, so he gives all the pertinent details of murder in text, also leaves a written note under the Furry's keyboard that's later destroyed, and now is going to plead not guilty. Cool. So, there's this prevalent, I don't know, attitude out there. It's like, oh, okay, this whole thing's just coming together so nicely. There's a little bit of skepticism, which is good. What's your thoughts on all of that?
It's his right to make the state put up or shut up. It's all of our right as an American to make the state prove it. Make them prove it. If you're going to accuse somebody, the burden of proof is on you. You don't have any obligation to, bare your neck for the state. So this is just the process that we have. If the state wants to give him a reason, to go ahead and make them not have to do that. If he has, maybe sometimes people do have their own internal motivation sometimes to just say, look, I don't want to fight it for whatever reason. He has the right to do that. But he's not under any obligation in a free society to say, oh, just because you accused me, I have to accept it. And whatever you feel like doing to me as a consequence of that. That's not American.
Yeah, I think what he's kind of saying here too, and a lot of people are, it's like, this is just all too convenient. Like somebody wouldn't make this type of, mistakes that, and to me, I guess a side note of this, I have a feeling, and again, this is just my own speculation. It's a feel and a vibe that I don't think he expected to get out of that alive. I really don't. But, again, the idea here is like, oh, he's a smart guy. He wouldn't have made all these simple mistakes. I don't know. You have a lot of experience with criminals. Do they make?
Yeah, guys, I'm here to tell you, thousands of criminals, they're not smart. Okay, it's like it's almost characteristic, like you could maybe almost spot them. There are no criminal masterminds. Okay, the closest thing we had to a criminal mastermind that I have seen in like maybe the last decade or so was Brian Koberger. He's literally a PhD forensics student, and he brought his freaking phone with him on the crime. He dropped his knife sheath there with his DNA on it. So they're able to connect it to him. There are no criminal masterminds. Most criminals are not very smart. They don't know what kind of evidence is out there. They don't think that people are going to turn on them and give up information that incriminates them. A lot of times they're just not even thinking that far ahead. Criminality, one of the traits it's associated with is impulsiveness, poor judgment, poor impulse control. These things just don't correspond with really careful planning to help you get away with it. Like, most people are just not smart enough to figure out how to not get caught for their crimes.
Yeah, no, I agree. And again, you're a lot of these people that are willing to do these things. I just have to imagine, kind of think differently than the rest of us normies that have a penchant for not murdering people. We're like projecting our own sensibilities on these people. Like, I wouldn't have done that. Well, I wouldn't have climbed up on the roof and shot anybody no matter what, like, much less, did all the stupid stuff that led to me getting caught. But I digress. David Morgan says, and this is, folks, this is kind of a segue into, I'm plugging tomorrow night's show. Tomorrow, we are going to have a full live stream addressing all the 30-06 stuff, right? We're going to address the ballistics. I'm going to have 2 different people on with me. And David Morgan says 10,000 gun experts say, if gun experts say it cannot be a 30-06, only one says it was, who will the judge believe? So first of all, let's talk about gun expertise and ballistics experts and things like that. Just because you hunted your whole life doesn't make you a gun expert or a ballistic expert. I posted on X earlier today, like, look, if you don't make a living shooting guns, like, you probably should sit this one out. I've been driving for more than forget how old I am. Almost 30 years. Doesn't make me a race car driver. I don't know exactly how my transmission works. Tangential experience doesn't make you an expert. I've been shooting. I was a sniper team leader in the initial push into Iraq. I was a Special Forces operator. I was 18 Bravo, which is a weapons sergeant. I've been to dozens and dozens of armor level schools. I've been shooting long range professionally since that time. I teach long range for a living. I teach ballistics. I've been doing ballistics testing before I was on YouTube. I've shot millions of rounds. All right. So I know a thing or two about actual ballistics. Whatever your pappy's 30-06 that would blow a horse in half, all right, is not like, I don't care about it. What I've said from the beginning is that terminal ballistics are extremely unpredictable, and that's a fact. And the other thing is, we don't know anything about that round. The 30-06 was one of the most ubiquitous firearms in the country. There are tens of thousands of different rounds for it that are sitting around. There are many varieties of rounds. I don't mean there's 10,000 different ones, but I'm saying there are people in their basements. They got all kinds of rounds from the 60s. I have a box of 30-06 over there from the 40s that somebody sent to me. The point here is that, and there's a wide gambit, all the way from like 55 grain up to 220 grain. And then you have all kinds of different projectiles. We don't know the weight of the projectile. We don't know the type of projectile. We don't know, was that store-bought ammunition or was that hand-loaded ammunition? All of these variables that would predict a ballistic outcome, everything that we need to know, we don't know anything about it. So what I would say is just that. Like, we don't have enough facts to make the determination. And one of the things that, like, Gary, go do ballistics testing. Okay, I'll go do some ballistic testing. Tell me what ammo he was using, and then give me his rifle. And then we need an actual person really to simulate this. Ballistic gel is not a good analog for human beings. It doesn't have the different densities of tissue that a human being has. It doesn't have ligaments. It doesn't have cartilage. It doesn't have muscle. All it is a ballistic gel. And then I have $2,000-$3,000 dummies over there that are torsos. And then, all the bones in it are basically plastic. So we can do some testing, but we need a little bit more information. And the idea, when you have this whole spectrum of ammunition types that are available, that you would get the same exact result from the lowest end to the highest end is actually absolutely ridiculous. It's dumb. And then on top of that, we also have some really good case studies. There are medical case studies where similar events have taken place. And then we also have Martin Luther King. Martin Luther King was shot in the face with a 30-06. That is absolutely verified. It lodged in his back. So not only was he shot in the face, his head didn't explode, the bullet didn't exit, and he still had an open casket funeral. So all of you ballistic experts that found out yesterday that you're a ballistic expert, like, sit down and just kind of chill out. Like, I don't pretend to be a lawyer, and Andrea doesn't pretend to be a ballistic expert because she went hunting a couple times.
I'm a skeet girl. I like shooting the clays.
You know what? Going back to that real quick, Andrea, let's say the ballistics, like you pointed out, there isn't any information on ballistics on that. And that was one of the questions I was going to ask you. Is that normal? And you basically said, hey, it's not normal. It sounds like it seems to be at least atypical that we don't have ballistic information in here. Is that kind of your conclusion?
I would just expect it to be there, because I would know that if they recovered a bullet from the scene or from Charlie, if it's, unless it's in a condition that like it's so fragmented that we can't get much information about it, you would just expect them to let us know, is this consistent with the firearm that was recovered from the bushes, or is it not? It's information I would expect them to already know. And so I would just, I would normally expect them to tell me it does match, it doesn't match, or why they aren't able to tell me.
Fair enough. Now, even if they don't have enough of the bullet to recover to actually match the rifling in the bullet, amongst other things, they can also match, the metallic cartridge to the actual chamber and the action and all those other things. Now, they would still be able to use a metallurgic test to be able to see if the fragments that are recovered from Charlie are consistent with the other pieces of ammunition. Is that correct?
I would expect that there's like a whole variety of forensics that they can do like that. Like, yes, they're going to be able to look at the materials themselves. There might even be trace analysis that they can do. Typically, again, it's going to depend on the details of what we're dealing with. What type of bullet is this? A softer metal. You might have some like residue of that in the cartridge that in the casing that you're able to recover and compare and see if that's consistent.
Let's say all the other evidence. Is it possible that they never matched that bullet to that gun, but with all the other evidence, could they still get a conviction?
It depends, I think, on why they can't match that bullet to that gun. If we can understand why they can't, I mean, it's a frangible bullet. It's like exploded. There's nothing left, for all intents and purposes. This is just kind of as an aside. I'm certainly not a ballistics expert and don't purport to be, but I have handled murder cases, and in most murder cases are gunshots. Now, granted, they're usually handguns. They're not rifles. But you deal with a lot of the same things in terms of just the unpredictability. Weird things happen when bullets intersect with a human body. Fragmentation is really common, and one of the things that happens with fragmentation is it diffuses a lot of the force of that bullet, into the body, and so you're far less likely to get like an exit wound or something if a bullet is fragmented. So there can be lots of issues like that. It's just there's not enough left that they're able to like reconstruct how it started out to be able to make any kind of meaningful conclusions about it. That might be an understandable explanation. If the explanation is the bullet isn't consistent, well, then that's probably going to be a real problem for the prosecution. Because if the bullet didn't come from that gun, then we've got a whole other issue.
Maybe they can't make a direct match to the gun, but if they have, let's say, because there's a lot of theories out there that there was a different shooter. Would they be able to tell, most likely, if it came from a different gun, and or would the defense be able to spot that if like the state and or federal agencies were trying to lie about that?
So where I think there is likely to be some room here, because the reality is, yeah, if there's something that, like, if there's an intact bullet, it's got rifling on it, like, this is going to be like faking text messages. The defense is going to have access to their own experts. They're going to be able to evaluate themselves. They're going to be able to call bullshit on, whatever story the prosecution is trying to put out about the bullet. So I think it's far more likely that if there's dispute about it, it's because we don't have enough to be able to make that kind of good direct comparison, and then argue about who's right. It's much more likely to be in a situation where we are looking at what is consistent, and we maybe can't say it comes from this particular cartridge, but we can say it's consistent with that. If there's something that allows us to rule it out from being associated with that cartridge, that of course would be very helpful to the defense. But so I think it's just much more likely to be in this gray area of, either there's just not enough there to be able to make a good comparison, and then it's not going to be solid evidence one way or the other. It's just going to be like, yeah, it fits, but it doesn't like say definitively the way that tool mark evidence might be able to tell us in other cases that it really looks like this gun or this rifle, and just. It's going to be a part of the circumstantial case. I mean, the thing is that, I say it's a circumstantial, most cases are circumstantial, at least to some degree. It just depends on, and that's not a bad thing. That's normal, because most crimes aren't like caught on camera. But it just, the stronger your case is going to depend on how many of these circumstances are all aligning in the same direction. And that's why I continue to point out, you got a lot to explain here with Tyler Robinson, because there's a lot of circumstances that coincide that are consistent with him being guilty. So it's a much stronger case, like even at the probable cause level, than, from my perspective, a case like Kohberger was. At the probable cause case, it's still a circumstantial case, but it's quite thin. They have, a little bit of touch DNA. They have some like general, location data that's within like a, maybe as much as a 10-mile range. And that's kind of about it. So this is not that. They got a lot of levels. They got the DNA, they got the camera, they got the confessions, they got the travel. I mean, there's just a lot of things that are stacking on each other to strengthen the circumstantial inference that you can draw.
Do you think the trial will conclude by January 20th, 2029? Could a new DOJ scuttle the case in any way? Thank you. Well, I mean, it's a state case at this point, right?
Oh yeah, it's a state case. The DOJ doesn't have any say in it. Now the feds can independently prosecute him if they want to. If there is a basis for them to do that. They're doing this over in New York with Luigi. There's a federal hook that firearm is used to commit a crime. Apparently, like any gun crime now, you can charge federally. But so yeah, if there's a basis for the feds to proceed themselves, they have the power to do that. But
they can't
drop. But they can't like
Utah drop the case.
Yeah, no, they can't shut down the state case. They have no authority there.
If he pleads guilty, many will still not believe it. In fact, despite all the evidence, if it does go to trial, I agree with that statement.
Yeah, I agree too.
Can his text be used as admission of guilt?
Yes, and they will be.
Do you think there were reasons unknown to us, the police, security, both Charlie Kirk's and UVU's, did not provide proper security? The only part I have issue with is why he was sitting. Continued. I don't know if we got more information. I kind of got the gist of that. I've talked about this, but feel free to opine on that, Andrea.
I really have no special insight into security or anything like that. I would say, to the extent I have insight in this at all, it's in how governments operate, and they're often, carelessness and negligence and not doing things well is just unfortunately kind of common. So maybe it's like a Hanlon's razor type of thing. Never, attribute to malice what you can attribute to incompetence. I think it's likely just a mistake. And for whatever reason, nobody followed up on it. But if there's evidence to the contrary, I'm sure we're going to hear that.
The rest of her was he was sitting higher than normal with all the death threats. You would think common sense would kick in, and with his security team, and something isn't right. Well, look, I mean, I know you guys think I'm a Fed or whatever else, but I did interview Brian Harpole. I've talked about this. I used to teach security for the Department of State, diplomatic security. Again, what you have is you have a close protection detail, and it is just that. They do not have the authority. The problem is most of you think that Charlie Kirk should have had the Secret Service and the POTUS level of security detail. It's not how this works. Security at that level, like they can't mitigate, they're not gonna be able to protect anything outside of a 30-yard or so bubble. A couple things to realize is that's where the shooter was. Number one, that is UVU's property. It is 140 yards away, and that is their physical property. So they're in charge of their physical security of their property. In the same way that if somebody would have climbed up there, it's an easy roof to access, and they decided to walk out there just to watch what was going on, and they fell off, who would get sued? It wouldn't be Charlie Kirk's security or Charlie Kirk. It would be the campus, right? On top of that, the other thing that you guys aren't taking in consideration is, having gone there, there are literally hundreds, I don't know about hundreds, there are lots and lots of rooms with windows that somebody could have went into and shot through. Was Brian Harpole and Charlie's security team supposed to go clear every single one of those rooms and then also secure them during the entire event? That's what Secret Service would have done. But instead of, $1 million a year security contract, when the president goes to a place, he brings, literally over 100 people, and it costs millions upon millions, several $1 million for one visit. There was always risk. He was in a crowd of over 3,000 people. They could carry guns onto that campus. If 10% of the people were carrying guns, which is probably somewhere around there was 300 guns within 50 yards or less of Charlie. And so they knew that was part of their risk assessment. So you had 13 guys on security. They were having to manage 3,000 people, and that's where they were looking at, because that's where the most likely threat is. I feel like a lot of people are Monday morning quarterbacking this. And then on top of that, you're Monday morning quarterbacking a game that you've never seen before. So private security, personal security, there's only so much that they can do. And there's lots of ways. I can figure out 50 different ways that I could have exploited the security flaws and do whatever, right? But we had one that was exploited. It was successful, and it was successful because it was easy. The easy access to the roof, the easy planning. They knew almost 2 weeks ahead of time where that was going to be. They knew it was going to be in the UVU courtyard. You look at that courtyard, there's only one spot where the speaker is going to be. It's easy to plan, and that's why it was successful. So, I mean, you can blame his security if you want. That's fine. But again, I think you guys are you're just expecting Secret Service level of security detail, and that's not what they were able to provide. And on top of that, Charlie, talking to Brian Harpole, Charlie rejected a lot of the things that they suggested and recommended. They didn't want that rope line open, but Charlie wanted it open so that the person could actually see them. And again, just like Harpole said, there was many times that they'd been in places that were much sketchier and were much greater concern that Charlie wanted to go there. And those guys don't have veto authority. I hear so many people saying, if I was Brian Harpole, I'd have got there and be like, nope, we're not doing it here. You're not in charge. Those guys are glorified freaking bellboys. It's like, this is where we're going. You guys do the best you can and try to stop threats. So that's my take on it. If it goes to trial, God bless the selection of the jury. I have 2 kids that live there, and one went to UVU. There's a major trans sympathy around there. I guess that's a statement, not really a question. I can tell you it was weird being. Have you ever been to Utah?
Oh yes.
I've never been. I've driven through, but when I went to Provo, you feel like you're in a Mormon place. I don't know how to say it, but then all of a sudden, as like walking around, you'd see these teenagers walking around like these furry hats and furry like ear things, and it's like it's such a contrast to everything else. Like it stands out to you, and the amount of them was really strange to me. I don't know. It is what it is. Yeah, and this is a continuation of what she was saying too. And if nothing else, postpone until it can be properly vetted as a safe place for all that were there. That's just, again, folks, I don't disagree with that's probably how things could happen. But when you have a big organization that's planning events, like you're going to that event and you're not going to be like, this place looks sketchy. I need to fix a few things before we can have this event. He's not the president. Andrea, I've been watching you since Rittenhouse. Question, peanut butter on French toast, yes or no?
I'm a waffle girl. You can have my French toast.
Would you put peanut butter on your waffles?
Unlikely. I mean, I wouldn't say no if I was offered the waffle and it had peanut butter on it. But if I had my choice, am I going to put the peanut butter on it? No, probably not.
Bronson, take it. Look, you're a psycho, bro. Nobody's putting peanut butter on their French toast. Does it make sense to investigate all lines of inquiry that could be involved in getting Tyler there, including people with motives close to Charlie?
I mean, so again, does it make sense to who? So for the defense, it's going to make sense to investigate, any potential thing that I can exploit. So if I have a reason to think, oh, maybe there's, somebody over here that's close to Charlie that didn't like him or whatever, and I can try to turn that into something. Okay. But again, remember, the jury is going to hear the whole universe of evidence. It's going to have to make sense in the context of the whole universe of evidence. From the standpoint of the state is going to be, doing everything in their power to get, an extremely detailed look at everything that Tyler Robinson has done. Potentially from the point that it first crossed his mind that maybe it would be good if Charlie Kirk wasn't, having debates anymore. Certainly like the immediate planning stage and stuff like that. They're going to absolutely be looking at his contacts, his communications, whether he was, asking people for advice, getting information from people, consulting with people for, suggestions or things like that. And all of that's going to be followed up on.
This is a comment that we hear a lot. There's a bunch of people out there that are, like, hey, there's already way too much reasonable doubt. This is basically he's going to get off. What's your thoughts on that?
I mean, it's going to be up to the jury to decide. They're the ones whose opinion is authoritative. There's the ones that matter. Your opinion doesn't matter. My opinion doesn't matter. We're not going to be on the jury. My experience is that juries, tend to be pretty diligent. They tend to be pretty common sense. They tend to not be like overly skeptical of what's presented to them. They take most of the evidence at face value unless there is a reason why they think they shouldn't. They tend to think that witnesses are being truthful and, or at least they're in good faith, unless there's like strong evidence that they should discount them. So I don't expect that the jury is going to process this case, when and if it's presented in the way that the internet is processing it at all. We're not a good proxy for what happens in a jury room.
With everything that you've seen, like, do you feel like there's already been reasonable doubt established?
It's very hard to say, because again, we've seen such a tip of the iceberg and we haven't seen the evidence itself. We've seen the descriptions of what the state says that the evidence is. I will say that if the state is able to deliver what they say that they have, they're able to authenticate everything. They're able to, present the witnesses to support, like, yeah, this is what happened. Tyler's parents, for example, Lance Twiggs, et cetera. He's not going to beat this case. Absolutely not. They have more than enough to get him. Again, just on the strength of his own words, it tends to be extremely powerful evidence to a jury. Very, very difficult to explain away. So yeah, I think if they can present, they can put up what they say they have, they're gonna get a conviction.
Interesting. Yeah. I'm trying to go through and pull out relevant comments that aren't just silly. Uh, I mean, here's kind of a good one. Like UVU could have prevented Kirk's killing with security lanyards for doors. You couldn't get in if not a student or staff. Most UK universities are secured, and we don't have campus shooters. So first of all, like just to be clear, that's not how you get on the roof. The roof is completely, there's an open stairway to it. It basically is a walkway that ends. There's a guardrail, and then you jump over the guardrail, and then you're there. So I'll probably pull up a quick video. Have you seen how easy it is to get to the roof, Andrea?
Mm-hmm. Yeah, I saw your video.
Okay. Yeah. So I mean, it's like, so there's no doorways to get there, and you can get there 24 hours a day. I do think that we're going to find out after more evidence comes back that I think Tyler Robinson had been there multiple times. Either he had already been there in the past. It seemed like even in the charging documents, when it's talked about Charlie Kirk being there, he's like, "Oh, that's a stupid place to have it." I mean, I don't know if that clearly indicates that he has been there, but that's possible. But he had over 2 weeks, basically at least 2 weeks to plan this. So he could have made multiple trips there and planned things out. I mean, we just don't know. But what I can tell you is it wasn't hard. I mean, there's nothing sophisticated or complicated about it. It doesn't take assassins. It doesn't take a trained shooter to shoot 140 yards. All the things that people throw at this to make this more complicated, more sophisticated than it actually is just hyperbole. It's as simple as that. Not that. Yeah, Rick Jackson, you're still able to be critical of me. I don't care if you're going to call me names, or my favorite thing is I'm paid by the Jews, or I'm a Fed. If you're going to say that, then no, that's ad hominem. That's not a discussion. If you have something to discuss, say it, and I'll address it. I don't mind that. Again, we encourage disagreement, but if you're just going to name call and throw ad hominems, we're not going to play that game. It's silly. And let me go right down here to the bottom. We'll see if there's any last ones. Yeah, I don't know. So I think that's about it. Andrea, got anything else that you want to add to all of this?
I mean, I feel like we've been, pretty comprehensive as far as, what is out there in terms of the evidence, what needs to be kind of accounted for in terms of examining alternative, theories and explanations and stuff. I think the only thing that I would add that we haven't really explicitly come out and said is that if there's any alternate theory that is plausible, that is viable, that has evidence to support it, nobody is more motivated to present that than Tyler Robinson and his defense team. And so, again, I know we're kind of in the habit of wanting and expecting the information on demand. The court isn't going to give us that. But if we have the patience to wait and watch the court process play out, that's the whole way that our system is structured. That's why we have an adversarial system, so that people are motivated to put their best case forward. And so Tyler Robinson's life is on the line. If there is any conceivable way that he can point the finger elsewhere that is plausible and that's substantiated, we can expect that he's going to bring that. And so by the same token, I think if you don't see that, that should be very telling. And I guess I want to add to that as well. Like, Yeah, you don't always see at trial what all of the facts are, what all of the evidence is, and so forth, because, there's rules of evidence and, standards for admissibility and things like that. But that's why people like me follow cases really closely, because if they have it and they're going to try to admit it, or somebody is going to try to exclude it, it will be in a motion. It will be filed. It will be argued in court. We will know about it. It just may not be at the trial, but it is something that will be vetted through the process. So I just want to, continue to encourage folks to be patient, to have some kind of epistemic humility about what we know about this case at this point in time. It is often not a satisfying process, but it's structured the way it is for a reason. It's to be fair to Tyler Robinson, make sure he's got all the time that he needs to investigate and respond. But there is going to be a reckoning. The cards are going to be laid on the table. We are going to get to see it. And I think once we have all that evidence, we're just in a much stronger position to have firmer opinions about what happened and, the investigation, how things were done, and so forth.
Oh, those are all good points. This gentleman is asking, well, how did they know where the stage was going to be? Well, folks, it is, let me pull this down and just kind of show this to you, and I'll make this big so that make sure everybody can see. That's the unique thing about this particular location, is there is only one place for it to be. Like this whole area right here, the UVU courtyard is set up to where the stage is going to be there. And that's, it channelizes the speaker. And so it's a very predictable spot of where it's going to be. And the thing is, and I'm trying to pull it up right now. I'm trying to pull up the 3D model. If I can get that thing it's a big program. It takes forever. I got a pretty decent computer. But the point here is that Charlie's location here, no matter where he was from, if we zoom in, all right, so from here to over here, all of that area can be viewed from that location. Now, where the actual shot was taken, if we look right here, all right, where the actual shot was taken was about right here, all right? And so if they had actually slid his whole tent over as far as it could go, and Charlie was just basically generally centered somewhere before we get over to right here, he would still have a clear line of sight to take that shot. So, I mean, again, that's what's really unique about this place, is if you are familiar with this place, where the speaker is going to be. So that makes it very predictable for the shooter to plan this whole process out. And, I don't know what else to say about that. That's just the way it is. All right, folks, I think we're going to close this down. We have kept Andrea on here long enough. Time passes differently on the West Coast. I've heard it's like twice as fast or something. But no, Andrea, listen, I really
it's just that life is better over here.
On your side of the mountains, on the other, you can keep Seattle and Tacoma and all the other stuff. Been there, done that. No, but I really appreciate you coming on. Number one, this was not only fun, you're very enjoyable to listen to. I see why you have such a great following on YouTube. You present things unbelievably well, and it's very enlightening and helping us knuckle draggers understand the legal process, the justice system. I think is really important. I don't know if they teach civics in this country anymore. It doesn't seem like it, but I love having you on. And like I told you, I'd like to have you on to talk about some other things in the future. So we'll stay in touch. And folks, number one, make sure you guys go check out her different socials, go to her Substack, leave her some money over there, a tip, I don't know, whatever, a monthly subscription, whatever it works. Keep this lady going and support her for what she does. She put a lot of time and effort into this. But yeah, folks, tomorrow night we will be talking about the 30-06 and the ballistics, all that in a much more greater depth. I got 2 special guests I'll be bringing on for that, and it'll be a great show. So stay tuned for that. Andrea, you stay right there. Everybody else, until next time, stay armed, stay ready. We'll talk to you.